people might move to North Carolina to make it difficult for a property settlement because they don't want in the state that they were in, maybe their partner, their ex-partner would get more property, so they moved to North Carolina as one of the states where you can not have to share your property rights. So in the specific areas where you're going to see the changes in family law, particularly in custody, currently our law says whatever the marital relationship is between the parties, between the parents, is irrelevant to the best interest of the child and who should have custody. I mean, the courts don't just per se look at the relationship and say, oh, you're not married, therefore you shouldn't have custody. I mean, the law does not allow a judge to consider that right now. But if the amendment passes, then it is saying that the public policy that's coming forth from this amendment is unmarried situations are not good, therefore they must not, we don't allow them under the law, we don't recognize them, we don't want to give them any benefits, therefore they must not be good for kids. And I see that we'll go back to the 50s way of thinking, which was if a woman was unmarried, had a boyfriend, spent the night, I mean, she would lose custody. That was what happened back then. The last case our Supreme Court has decided about a gay parent situation involving a custody dispute not between two same-sex parents, but between a gay father and a divorced, his divorced wife. Back then, our Supreme Court said, just the fact that the father was gay and was living with his partner was detrimental to the children, and therefore he should not have custody, even though he really had been raising the children for some years. And so this is our Supreme Court who did this and it hasn't changed its makeup a whole lot, which I will get to at the end. So that's scary. And then we actually have good law right now in North Carolina about custody disputes between same-sex parents. So, and in fact, I like to say we have better law than New York or some other states. And that is, that if you can show that it was a joint decision to parent and you raise a child together, then the non-biological or non-legal parent would have rights. Some custody visitation rights. So we have good law about that. Unfortunately, whether the courts will then say, oh, well, now based on the amendment, that law doesn't make sense because it's based on these parties' relationship. I mean, we can't talk about their right to custody without talking about the fact they have a relationship. So we could lose that good law that we have right now. And it could bring the rise to relitigation. People who lost, or in a sense, and think that this amendment will help them, you can always go back to court and ask the court to reconsider a custody case. So they can say, oh, I'll go back to court and maybe this time I'll get a better ruling. Many of you may have been reading about and seeing there was a good article in the Charlotte paper over the weekend on how the amendment would affect domestic violence and other criminal statutes. And currently, under our domestic violence statutes, same-sex couples, if they've lived together, they can avail themselves of the domestic violence statutes. There's one way that we weren't covered, same-sex couples were not covered, and that was if they were just dating but hadn't lived together. Opposite-sex couples could bring domestic violence charges, but same-sex couples weren't. So the last couple of years we've been working to try to change that. But again, so now instead of moving forward, we're going to have to, be holding the gate and fighting for what we have. And again, this is not so much a scare tactic. We can look at places like Ohio, which dealt with this in their they have a constitutional amendment. So this is often what happens, things you don't think about. So a lot of criminal defense lawyers representing straight men decided, well, based on the marriage amendment and the non-recognition of unmarried people, that therefore the domestic violence statute shouldn't apply to straight men in disputes with their girlfriends. So, and in fact, many of the Ohio cases, till ultimately got up to the Ohio Supreme Court, said, well, you're right. And throughout, so all these domestic violence cases were being thrown out of court between boyfriends and girlfriends based on the marriage amendment in Ohio. So I think it's not, these things are not, we're not just throwing things out there that might not possibly happen. We have examples where they do. Fortunately, in the end, the Supreme Court of Ohio finally said, no, that's maybe going a little bit too far. And finally, in the area, before I talk to you all to death, speaking of death, estate planning, that's what I was going to talk about next. Currently, this is one area where, again, documents were really helpful. That, the law, of course, as you all know, is, if you don't die without a will, it's going to go to your closest family members, and spouses had all sorts of rights, the presumption that they were going to get things, and so, but there was many ways to do things differently than what the law would provide if you don't have a will. So you could have wills, you could have trusts, you could do all sorts of powers of attorney, naming your partner or whomever, your sister, whomever you wanted as your healthcare agent, and you could provide for many, many things in wills and powers of attorneys. And so now all of these things are going to be called into question, and whether we're going to, again, go back to even worse than it used to be. And particularly, like in wills, things that I include in wills for same-sex couples is that you want your partner to make funeral decisions. If you do not have that specifically written in a will, a funeral home will not pay attention to the partner, will do whatever the family wants. If the family wants to come and take the body back to Kansas, they can do that, and and without the partner having any say. So that's one of what I think is one very crucial thing I put in wills. It provides a mechanism for naming your partner as a guardian of your children, particularly now that your partner can't be a legal parent, so the only way you can protect your child at death is the guardianship. That's in the will. I have language, I know what I'm doing, I want to leave it to my partner, those kinds of things. Interestingly, in my 30-some years of practicing law, it used to be we really feared whether family members would come in and dispute wills and stuff. And I'm pleased to say that I asked that question. A lot of people I ask that to. My younger clients, they look at me like I'm crazy, right? What do you mean my family, doesn't like my relationship? So I think that for many people that's less of a problem, but there are still stories out there, death of a partner, the family brings the U-Haul in and is cleaning out the house before the body is disposed of, and this, of course, is families that haven't been around for years while the partner's been taking care of the person who's dying for the last year or two. And I've had cases where families have said, if you don't give me the money in this account, you can't come to the funeral, even though the money was a joint account, it was partner's money, but you've got to give it back to me or I won't let you come. And so I think the effect of this amendment could also encourage families to take advantage, to do more of punitive things like that. It may sort of encourage them to do that. So a lot of these are contracts. The trust, we do trust so that if people want to be more private about it, it doesn't become a public document. You just say in your will, I want to leave everything to my trust, and then the trust is never part of the public record, and some people that's been a good thing for. And it's sort of like in the last week I've had almost every client I've met with has raised issues based on this amendment, and it just is really hitting home to me. Like what I used to do in wills is say, I leave everything to my life partner, and in the beginning when you say who your family is, I say my life partner is so-and-so. And based on this amendment, there's some concern that perhaps we shouldn't say life partner, because if you say life partner, they'll go, aha, it's about an unmarried relationship, therefore we're not going to say this document is valid. And I really hate that thought, because people want to say that this person is my life partner. I mean, I have to argue with people who want to say this person is my spouse because they got legally married in Ohio, and I say, but no, we better not say spouse because that could cause some problems. But now I'm having to say, well, maybe we shouldn't say life partner. And one of the reasons I like putting that in is it was a real educational tool for when I go down to the clerk's office and have to probate a will. We don't have to play any games. We don't have to say it was my friend and my companion and those kinds of things. We get to say, that this was my life partner. This is this is the person that was significant in my life, and that's why I'm leaving him or her things. And I think I hate to go back to, and I think it really did educate clerks and judicial officials and everyone. So I don't like that being taken away. And again, one other scary story, just as scary as much as possible. Even in Nebraska, based on their constitutional amendment, their attorney general concluded that the legislature they wrote a letter to the AG and said, will you tell us if this proposed legislation would be any problem based on our amendment about marriage? And they were proposing a state law that would allow domestic partners to dispose of their partner's remains and to make organ donation decisions. And the Attorney General said, oh, no. Said, yes, that would be a problem. And why? Because such decisions were traditionally reserved for surviving spouses, and granting rights to same-sex couples would be akin to recognizing their relationship. So therefore, they won't even allow domestic partners to dispose, to make funeral and these kinds of decisions. So, and what's the one other, just real quick, because I'm running out of time here. The other area, if you want to ask any more questions later, is employee domestic relations, domestic partner rights. And there's question whether private employment will be allowed to continue domestic partner benefits. That's maybe questionable, but certainly it's going to prohibit governments from providing domestic partner benefits, including the 7 towns in North Carolina that currently offer that. So, in conclusion, just a couple things, and again, veering from the facts, I can't not take advantage of the time to give some political points. One thing I read that was pointed out to me in the Durham Herald, no less, in their editorial about the amendment, was that 2/3 of North Carolina population lives in communities with less than 50,000 people. So again, we get a little skewed here. And that is where gay people live, and that is where their rights will be determined. They're going to be facing these issues in front of local judges, court officials, and law enforcement. So although it may be hard for us to believe some of these things as we live in a triangle, life has not changed in counties even as close as Lee County. I went down there last year for a custody dispute, and I thought I had gone back to the 50s. It was clear the judge did not like gay people, did not like me, was not gonna cut any slack, and there was just like, there's nothing you can do when a judge rules a certain way other than appeal it, which costs an incredible amount of money for folks, and they often can't do that. So my political points is one thing, and I do have a fair amount of these if you want to come up and get them, is in our excitement and zeal to make sure this amendment doesn't pass, there's some things not to forget, and one is judicial races. I would, in light of some other comments I made, those of us who are in Durham, I think we have an extra burden to really get out the vote to counter what possibly could be the votes in smaller areas. So I think that's significant. And so my pessimistic side hates that we are facing such a scary legal and political possibility, and that will be so hard to undo in the future. We'd have to go back and do another constitutional amendment. And that I hate that we are in a battle mode with folks instead of working together on issues. But my optimistic side is glad we have an opportunity to tell our stories, that we have this great media attention, and that it can be used to educate all who will listen. So and my very optimistic side is that I look forward to seeing all of you on the evening of May 8th to celebrate the defeat of this. Can I say that? Yes.